Indeed for joining me today. My name's Sanaz Saifolahi, and I'm a practitioner at Goldsmith Chambers, specialising in immigration, asylum, human rights and public law. It's great to see so many new names and so many old names, and it's just unfortunate that I can't see any of you here today in person. But nevertheless, I hope you enjoy this webinar session on remote hearings and evidence from witnesses who are overseas. Now, I'm going to be concentrating primarily on first-tier tribunal and upper tribunal hearings today, because it's within these hearings that the majority, if not all, are being conducted via remote means, over CVP and also over Skype for Business. And I was very, very inspired to do this webinar because I've recently been instructed in about 3 cases where the issue of an overseas witness has cropped up. And I'd like to say a thank you to Joseph, who I hope has joined in this webinar, because it's with Joseph, who had instructed me through his organisation, that we went through the various steps that we need to take when calling a witness who's overseas. Remote hearings are not ideal or sufficient in a large number of cases, particularly if you're dealing with, for example, an asylum case, or a case where seeking the authority from the authorities for an out-of-country witness to give evidence is likely to put your client at risk. So I would suggest that you think very, very carefully indeed about the type of appeal that you're dealing with. On the other side of the coin, you will have cases where you wouldn't have ordinarily have even thought about calling an overseas witness, and this is a new opportunity for you to do so. For example, you may have an Article 8 appeal where your spouse is out of country, and the evidence from that spouse is going to be very, very useful to the issues in the appeal. So it really does depend on the kind of case that you're dealing with. So for the purposes of today, I'm going to be working on the premise that a remote hearing is the ideal scenario, all things considered. And I'm going to be addressing 3 main areas. If I can just try, there we go, it's worked. So the first issue I'm going to be dealing with is timetabling and pre-hearing planning, which I hope you can see on the screen share. So within this subheading, I just want to say a few words about the appeal skeleton argument and the potential for a case management review hearing. The second head I'm going to be dealing with in more detail is what to consider and what to do when calling a witness who is overseas. And finally, I've got a few tips and tricks about the remote hearing day itself, which is largely through trial and error. But it's a few things that I'd like to share with practitioners and people who are involved in that process that may hopefully make things a little easier, or at least help things run more smoothly. And of course, that doesn't include Zoom frames. So let's go. Timetabling and pre-hearing planning. I should have said, sorry, I was told this, but I should have said, if you have any questions at all, please pop them in the Q&A box, and then I will try to get to them all at the very end. If I can't answer all of your questions, then what we can try and do is you can email me, and my email address will be available at the end, along with my clerk's email address. So I'll try my best to fit them in, but if I don't, please continue to put your questions in and I'll do my best to answer. Sorry, bit off track. Right, timetabling and pre-hearing planning. So the appeal skeleton argument, we've got 28 days from the day that we receive the respondent bundle to file and serve an appeal skeleton argument, or 42 days from the date of the notice of the appeal, whichever is the later date. It's a very good opportunity within the ASA to address your client's case, the arguments, and respond fully to the reasons for a refusal letter. And this is to enable a meaningful respondent's review. So that's the ideal scenario. If there are any new matters to raise, please do consider raising them within the ASA as well, because when the respondent comes to review the refusal, they can then decide if they uphold it, if they're going to offer consent to you arguing that new matter. If you are instructing counsel to draft the appeal skeleton argument, then please consider instructing them sooner rather than later, because they could then themselves review the refusal and give you some pointers on what evidence you might want to collate and collect to put together with the original appellant bundle, which needs to go with the appeal skeleton argument. Remember, the appellant bundle needs to go with the appeal skeleton argument to the tribunal and also to the Home Office Presenting Officers Unit to enable a meaningful review of the refusal. So a few words on the respondents' review of the ASA. I found last year that I was getting so many responses to the appeal skeleton argument, all within the 14-day period that they were supposed to come to. Many of them were conceded following receipt of our evidence and the appeal skeleton argument, and it seemed to be working like clockwork. I was so impressed. More so now, I'm finding that the reviews are either not taking place in the timescales that they need to take place in, or when they are, they're largely generic reviews. But that shouldn't put you off. Please use that opportunity to put together the full arguments that you want to canvass. And if you can't get everything together, for example, an expert report or any other evidence that you would need, you can always file and serve that later. As long as the core arguments are put within the ASA, that's all I ask to happen at this particular stage. Remember, it's an opportunity for your client to be granted leave or a concession. Right, case management review hearing. There are quite a few that are held on BT Meet on the telephone, and also there are a vast number that are being held as a tribunal caseworker review type scenario, so not requiring any attendance from anyone. But if you need one, if you need a case management review hearing, don't be afraid to liaise with the tribunal or advise those instructing you to liaise with the tribunal to ask for one, because they can in fact be really helpful. You could save a lot of time and money in the long run, and it might be that some outstanding issues can be resolved within that remote case management review hearing. I recently had a full hearing which we asked the tribunal to transfer into a case management review hearing because our client was vulnerable. Excuse me. And once we'd done that, we were able to resolve firstly the issue that the respondent hadn't responded to the ASA, which they then did. They then conceded the case, and it all made everything much simpler and much easier and more smooth line. So I would advise, if you need one, please don't be afraid to ask for one. And if you get one, then you'll want to address what are the issues in the case, what is accepted, what is rejected, are there any new matters that you want to raise, has the ASA been drafted, has the respondent review been undertaken, do you have any missing evidence, is there anything that the respondent refers to within the refusal letter that you don't have that you need? Do you need any other directions? And most importantly, for the purposes of this webinar, who are you hoping to call as a witness? Do you need to highlight any issues in relation to witnesses overseas? Which is what I'm coming on to now. So calling a witness who's overseas, these are the suggested steps and also the required steps. When you're preparing the appeal, you'll want to consider, firstly, the type of appeal it is. Is it entry clearance? Do you have a witness who's overseas? Is your client overseas? Is it an option to call the witness or your client, bearing in mind the core issues to be determined? And this is really the issue I started off with is it going to put your client at risk? And you will see when I go through the process that you have to go through in respect of calling some witnesses, that there is a possibility that their details will come to be known to the authorities. So you really have to think carefully about that. The other thing is that sometimes we overcomplicate things. So is this a kind of appeal that you could deal with on submissions? Are there any contentious facts? If the facts aren't an issue and it could be resolved on submissions only, then why call your witness? Why complicate things? So think about that as well. Think about what's an issue. And as I said at the start, Remote hearings are also an opportunity to call witnesses you wouldn't have dreamt about organising their evidence for in the past. For example, a spouse out of country, you probably would have had a witness statement from the spouse, you wouldn't have organised pre-recorded evidence, you probably wouldn't have organised them to give evidence via video link unless it was a very unusual case. So it is also an opportunity, in my view. So what do the procedure rules say about this type of evidence? Oops, sorry. Sorry, I think one of my slides has disappeared, but I'm just going to talk to you about it. Oh, technology. Right, so the procedure rules. The first tier tribunal procedure rules, you're dealing with Rule 14. So these will be available on our website in full, by the way, so you don't have to worry about noting this down. But Procedure Rule 14 is the relevant procedure rule within the first tier tribunal procedure rules. And that is in relation to the directions that the tribunal can give as to issues on which it requires evidence or submissions, the nature of the evidence or submissions that it requires, and whether the parties are permitted or required to provide expert evidence. So the rule also addresses the manner in which evidence or submissions are to be provided, which may include a direction for them to be given orally at a hearing, or by witness statement, or by written submissions. So this Rule 14 is quite a general rule in relation to evidence, and it does give quite a large discretion to the tribunal in relation to the manner in which evidence is given. But nevertheless, that is the rule that you will be looking at as a starting point. The mirror rule in the upper tribunal procedure rules is Rule 15, so you'll also be looking at that. There are also relevant extracts to be located within the upper tribunal Immigration Asylum Chamber Guidance Note 2013 number 2, video link hearings. So again, this will be available on the slides on our website hopefully very soon. But what this guidance note deals with specifically is video links in overseas cases. But please bear in mind the date at which this particular guidance note was published, 2013. So we're talking a long time before the pandemic, where video hearings or evidence to be given via video means was unusual. And that is very much the flavour of this guidance note, because when you consider paragraph 13 of that guidance note, you will see that the tribunal needs to balance out the need for that evidence versus how difficult or easy it is to be able to receive that evidence in the interests of justice. So sort of what I referred to at the start about what the issues are, but slightly different because obviously at the time it was written and published, it was a rarity. But what is important within this guidance note is paragraph 14, which I'm going to read out, and then I will take you to the next slide, which is a reported case which follows on from this guidance note. So paragraph 14 says, it should not be presumed that all foreign governments are willing to allow their nationals or others within their jurisdiction to be examined before a tribunal in the United Kingdom by means of video link. If there is any doubt, the party making the application should make appropriate inquiries with the Foreign and Commonwealth Office, PS no longer exists, is the FCDO, with a view to ensuring that no objection will be taken at diplomatic level. Wow. That's what I thought when I first read it, because there are so many cases where you would easily have just sent a CVP link to your client or the witness overseas and asked them to log on to give evidence. But actually, what this guidance note makes clear is that this is not a presumption. Then we come on to the reported case of Nair or Nare. I don't want to mispronounce the case, which I've been known to do in the past, but this case was from 2011, again, pretty old, and this deals with the issue also of video link evidence. So I've given you an extract paragraph from the case, but I would invite you to consider the case in its totality. if and when this issue crops up in one of your cases. Paragraph 33 of the case goes through the steps to undertake in relation to witnesses who are overseas. But again, bear in mind, it is old and it is pre-pandemic. But again, this particular paragraph highlights the importance of whether you need to make an inquiry with the Foreign and Commonwealth Office. Again, it's the FCDO. And it also highlights uniquely that if evidence is given from abroad, a British Embassy, High Commission or Commonwealth may be able to provide suitable facilities. Well, no, actually, because firstly, it might put my client at risk. And secondly, how reasonable or appropriate is that in the current state of the pandemic? So we're just pulling out various bits of guidance from the only sources we have available. And then I'm going to give you at the end what I advise you to consider when taking the relevant steps to call them. Then the case goes on to outline that you need to serve an application to call a witness from overseas on all other parties. So basically the Home Office, so everyone's on notice. And the decision whether to grant the application is a decision for the judge, having taken into account what both sides say. Again, the emphasis is on the fact that this is an unusual course to take. It's not one that we would normally take, which clearly is not consistent with our times. So please look at narre fully if you have a witness who is overseas that you want to call. The last case that I want to draw your attention to before I go through the process that you will consider adopting if you have an overseas witness is CJ. So you have the citation here. This is a more recent case, so it's not particularly old, but this case deals with the fascinating issue of GDPR. In case any of you were wondering, can I call them? Am I breaching data protection? I hadn't even thought about that. But anyway, this case essentially says, no, you're not, because it's the transfer or defense of legal claims. So in this case, the witness was giving evidence from Jamaica, and they were concerned as to whether or not this would be breaching data protection by the witness giving evidence, because it was a transfer of information from outside the country into the UK. And it was determined that actually no, because firstly, the appellant had given consent, and secondly, it was a transfer of information in defense of a legal claim. So those two elements meant that it was GDPR compliant. Just in case any of you were worried about that, I wouldn't recommend reading the whole case. It's a bit of a bore. However, the head note's probably enough for you to feel comfortable that you're not breaching any data protection in the circumstances if you're calling an overseas witness. So, having gleaned from the procedure rules, the guidance note, the reported case, I haven't gone on to more recent cases like Chiari, where they considered video evidence and they thought, well, actually in-person hearings are superior, because I think we're in a very particular time right now, and it has necessitated the need for video hearings. So we're really looking at ensuring that we're not breaching any protocols, any international law, any GDPR, and that we're doing things correctly in the right way. So what are the questions that you ought to ask yourself when preparing a case where you may have a witness who's overseas, and what are the steps that you need to take? So firstly, who's your witness? Is it someone who's important to hear from? Is it relevant to the matter and issue? Are you going to benefit from hearing from this witness? Is it enough to perhaps just have a witness statement from that witness? That's also something you want to think about. So really, really go into the nitty-gritty of the case and the issues in your case. Where is your witness? Which country are they in? They could be a British national who's stuck in another country. The case that I spoke about recently, that I was instructed in, my client, who was Colombian, was actually in the UK. Her husband, a British national, was stuck in Vietnam. So it was the reverse from what we're ordinarily used to, but we still needed to make sure that we were going through the correct channels and the correct steps. So this is the important part. You need to check the Convention of the 18th of March 1970 on the taking of evidence abroad in civil or commercial matters for some guidance. So again, on the slides when they're available, there will be a hyperlink to take you to this official list. So this is essentially a list of countries, and you will be able to locate from within this list which countries are on the list and whether the UK has accepted the accession of that country. So please look carefully at the listing, because it might be that a country appears on the list and you might think, oh, so they're on the list. Does that mean I'm fine to call them without seeking any other guidance? No, it doesn't, because what you have to make sure you do is click on the correct link, which will demonstrate whether the UK has accepted the accession of that country to this convention. For example, you may have Brazil. So if you click on Brazil, it will take you to a status list table. When you check the status list table, you will therein be able to see if the UK is on that table, having accepted the accession. Some of the countries that appear on this list, and this isn't all of them, it's just some of them, include Argentina, Ukraine, Belarus, Latvia, Mexico, Poland, the Russian Federation, and South Africa. So I've dealt with a number of cases where my witness is in South Africa and the judge has been satisfied, this is pre-full hearing, the pre-full hearing stage, that because there are friendly diplomatic relations and because the country appears on an accession list, which I've just demonstrated where you'd find it on the convention, that it's fine to call the witness. That was the judge's decision. So the premise is, and this is pulling together from the case law, from the guidance, and from the list, the premise is that if the UK has accepted accession, the countries on the list, you don't need to do anything else before you call that witness. But I wouldn't stop there in the vast majority of cases, because things can move quickly. We're not experts in international instruments and how long it takes for a session to come forward. That there is scope for, I think there is scope for problems. That's my view. I may be being overcautious, but that's my view. So I would advise, if possible, and I say if possible because it depends on the case that you have, that you still contact the Foreign Commonwealth Development Office to ask for their guidance in respect of your witness and the country that they're in. So what you see on the screen is the gov.uk website link, which deals with video link evidence. And if you go onto that link, you will see the full overview of where the inquiry needs to be made, to what address, even though the address appears on the slide there, you'll see it, it's soapinquiries@fcdo.gov.uk. So that's where you need to go in order to contact the FCDO. Now, in my experience, I have to say this now because I'm sure many people are thinking, well, how long is that going to take? In 3 of the cases that I've been instructed in all 3, we had a response within 24 to 36 hours from the FCDO. I was utterly shocked and blown away. But in every single case, they came back within 3 days with a really, really helpful response. So don't be put off by any concerns that you may have about how long things will take, because in my experience, they're extremely quick. So that's where your inquiry needs to go. The web link that you saw on the previous slide also asks you to provide quite a lot of detailed, specific information about your case. And you'll see some of it on the slide there. Names and addresses of the parties to the proceedings, the nature of the proceedings, a full summary of the action, the names and addresses of the persons to be examined, the evidence to be obtained, the specific questions to be put to the person examined, or specific statement of subject matter, documents, so on and so forth. And then if the FCDO don't have the answer, then in some cases, although this I haven't had experience of, they may need to refer through diplomatic channels to that specific country if it's not clear what the position is. But in all three of my cases, the FCDO has come back with either you may call the witness, it doesn't matter where they're giving their evidence, their accession has been accepted by the UK, it's fine. Or you need to do something else, which is what I'm coming on to in a moment. So the CPR 34.13, we know that we don't need to go to the CPR within immigration proceedings, but there are cases where we've gone to the CPR for a little bit of guidance in terms of what is entailed and what is required. And within this part of the CPR, you will see that there is a procedure that's highlighted for individuals, namely legal representatives, to call a witness who's out of country where they're not part of an accession state. And it's essentially dealing with a letter of request. So there's quite a few steps that need to be undertaken if the UK has not accepted the accession of a country. That process, as far as I can glean from what they advise us to do, I think is likely to take some time, particularly given the channels that you need to go through. And so have a look at in your own leisure time at 34.13 of the CPR, because there you will see the process that's required. It also includes a letter. I'm going to come to a case law example in a moment, so you can put this into practice. But in summary, it's the letter of request to the judicial authorities in that country, and there's a step-by-step approach that needs to be undertaken. So I'm just going to summarize a case example. I can't read it verbatim, but I can give you a summary of a response that we had in one of my matters from the FCDO in relation to calling a witness from Vietnam. So this was what they had advised us to do in the case of Vietnam. And what they said is you would need to contact the Royal Courts of Justice, the Foreign Process section of the RCJ, ask them to prepare a letter of request to the competent judicial authorities in Vietnam, requesting the taking of evidence by video link. Therein you would explain the nature of the evidence, so on and so forth, more details about the individual who's going to be giving evidence. You would then need to accompany that letter with an official Vietnamese translation, and then it would be forwarded by diplomatic channels, if necessary, namely via the embassy. And the response would be received via diplomatic channels, and that is all done for the bargain price of £150, apparently. And there was some more information contained within the email that we received from the FCDO, but for the purposes of this webinar, those really are the pertinent points to highlight and to canvass, and they are consistent with the CPR requirements as well. So I find that very, very perplexing, actually, in the current climate, because first and foremost, that's going to take a very long time. Secondly, the process which they're advising us to follow is essentially one under the CPR. And whilst, yes, it is a civil matter, we're not governed, strictly speaking, by civil rules. But what guidance do we have? The guidance that we do have is very old from the tribunal. It's guidance from 2011 and 2013, which is advising us to ensure that we can call a witness from overseas, and that information is forthcoming from FCDO. So we come back to the same situation. I just fear that there is a real missing, there's a missing link here, and I really hope that it's dealt with quite soon within the tribunal so that practitioners can have some guidance about exactly what to do. But where we are now, and what we have now, this is, as far as I can see, the most pertinent approach. This is the safest approach to adopt, I think, if you're looking to call an overseas witness. You obviously don't have to follow this process, but from what I've read and researched, it's the most appropriate process to follow. Now, in that case, the respondent actually ended up conceding the appeal, which meant that we didn't need to go through all of those hoops, thank goodness. But actually, once we'd received the information, we sort of touched base and we discussed it, and we thought, on balance, we could do with just having a witness statement from that witness, because the lead issue wasn't the contentious issue that the witness could have assisted with. It was more of a backup argument, but all things considered, it just didn't seem like the most sensible approach. But at least we know, and we knew what we needed to do had we wanted to call this witness. So again, this really highlights the need to balance out who you're calling and where you are, where they are, and what you need to do. So in summary, I would suggest these things that you can see on the screen. Early pre-hearing planning, really, really important. Check the Hague Convention list, check your procedure rules and the guidance, see what your interpretation is of it. If you need to, you can contact the FCDO via email, and as I said, their response times have been so good in my experience. They've just been brilliant. So you can go to them, think about whether you need to update the tribunal and the respondent, and at which stage. If you're reviewing your file and you decide to call a witness, or that you need to call a witness from overseas, think about a CMRH, think about a letter of representation to the tribunal caseworker, to the Home Office, so everyone's on notice, so it doesn't disturb the flow and the timescales of your appeal hearing. I have heard in some cases, and this is giving me hope, that the tribunal has actually picked up on this issue themselves. So in some of my cases, sorry, not in my case, in some of my colleagues' cases, they've notified me that the tribunal has issued a direction stating that there is likely to be an overseas witness in this case. Please, can you provide evidence that you can in fact call this witness? So this relates to FCDO confirmation and or the Hague Convention list, one or the other. And I would be slow to take the full responsibility of calling the witness. I think it needs to be shared. So as long as you are highlighting the issue to the tribunal and the Home Office, I think that demonstrates that you're forward thinking and that you're thinking about the channels and the steps that you need to undertake. So that's always a good thing. You can't possibly be criticized for that. And it also means that the Home Office might think about the issues in the case, and they may end up conceding something, which is what actually happened in my case when they read the rigmarole involved in actually calling this witness in the end. So everyone was happy in that case. And finally, make the necessary arrangements for the witness to give evidence. So if you can call a witness who's overseas, the FCDO has confirmed in a couple of my cases that it's fine for them to give evidence at home. Obviously, there's a pandemic. They may not be able to make it to an embassy. They don't even need to go to an embassy. As long as they're somewhere private and they have secure internet connection, then they can give their evidence as anyone else would on a CVP link. So that is a summary of where we are with calling a witness who is overseas. So a few tips for the remote hearing day from my own experience. Please check your computer and your settings. So obviously check your audio is connected, the video is connected, not just yours, but also your witnesses, your clients. If you can possibly have a test run of CVP, that would be absolutely brilliant. If possible, on the day, have a telephone con with your client, or better yet, a Zoom with your solicitor, client, counsel first. Talk through logging on, talk through the steps, how the screen's going to look. I've tended to do this in all of my cases about 2 hours before the hearing time, because even though it's additional time from my timetable, it actually makes my life so much easier, because it means everyone sort of knows what to expect. It's quite scary for someone who's not that in tune with the internet to think about giving evidence on CVP. It must be quite daunting. Don't forget to advise your witnesses to be in separate rooms, and to be separate when they each give evidence, and to ensure that they don't speak to each other, just as it would be in the courtroom. Try and log on 30 minutes early to CVP and Skype to ensure connection, sound, that you know how to mute, turn off your video, use the chat box. If you're representing and you are instructed by a solicitor or caseworker, if they can log on with you, it's so helpful, because I've had cases where the clerk comes on first and then we'll check through the paperwork. And if you're able to log on as a solicitor or representative to ping over some documents, because the clerk can put the email address in the chat box there and then, and it saves so much time. So if possible, if you can log on briefly before starting, it really is helpful. And as I said, the Home Office and the clerk can put the judge's or the clerk's email address in the chat box, and you can then ping over the documents that are missing. So those are my top tips as well for the remote hearing day. So that is a run through, as far as I've gleaned, where you go with CVP links from out of country. So I really, really hope that was helpful. I'm going to see if I can use this Q&A box now. Let's give it a go. So I'm clicking on it. Hold on. Let's see. Chat. Okay, here. Oh, great. Okay. Oh, that's nice. Thank you. That's really sweet. Oh, I'm glad. Okay, so as far as I can see, and it's quite possible I'm missing something, but I can't see any questions apart from whether the recording will be made available, and then something really sweet as well about it. But if there are any questions that arise later, oh dear, where am I? If there are any questions that arise later, then please feel free to email me or my clerks about it. Oh, here's something here. All right. Yay, a question. Sorry if I've disappeared, and if I'm tiny, I press something. I don't even want to press it again. So I'm just going to go straight to the question. Okay. I wonder if you could give us a bit more advice as to how to weigh and assess the risks around identifying an individual abroad as involved in asylum proceedings. If we're seeking to take evidence from someone resident in more repressive or risky environment, what steps do we need to take to ensure we're not exposing them to more risk by virtue of their inclusion and involvement in proceedings? In this case, I am principally concerned about identifying them to the authorities in the other country. It's so difficult. It's so difficult. And I'm so pleased you highlighted this question, because this is really what I wanted to home in on and focus on throughout, because it really does depend on your case. Because of the information that you need to give to the FCDO, I would be very slow to seek to call a witness from overseas in respect of an asylum appeal. That's my opinion. Not having said that, there's also the risk of the actual video link itself, and whether that in itself is likely to put somebody at risk. So you need to think about that as well. don't forget, you also have the option of having the hearing as a face-to-face hearing, but that would probably mean quite a long adjournment. And you would want to put all of those factors to the tribunal to ensure that they know the reasons why you want a face-to-face hearing instead. Now, that doesn't specifically address the issue of the witness from outside of the UK. It doesn't. But if somebody is in a state, a repressive state, a state outside, or if they have a fear of the authorities, how on earth can we be representing them by offering their information to the very authorities that they fear? It's not possible. Therefore, I would urge you to err on the side of caution in those cases. And it cannot be held against you that you've taken that action because it speaks for itself. But please make sure that you consider everything. Please, please, please. There's something about the ASA. 28-day period or 48 periods from notice of appeal, and notice of appeal is lodged at the start of the appeal. So shouldn't this 28-day period or 40 days period from the acknowledgement of the notice of appeal or direction notice? Yes, you're right. So please, the directions themselves for the ASA will specify exactly the time period that you need to adopt and from when. Yes, so just make sure you consider those. I was just giving you a very general overview of the 42/28 days that I've read in my cases. And actually, I don't often deal with the deadlines because I'm just told, can you do it tomorrow, please? We really need you to do it tomorrow. So yes, please check your directions and your time scales for the ASA. But please do an ASA. They're really, really helpful. I don't think there are any more questions. So unless there's anything else anyone wants to ask, please note that the slides will be available. I'll try and have them on a hyperlink so you can just click onto where you need to check the countries list and also the FCDO information. So it should be much, much easier for you to access. And until then, I hope you all stay safe. Well done for working in this horrible climate, and hope to work with you soon. And please do check out the rest of our seminar series. We've got some fantastic things coming along. Take care, lots of light. Bye.